A confession is the most powerful evidence in a criminal trial, and it's because of the tremendous significance and because of the hard-won experience that confessions can be obtained by improper means that they have been for centuries carefully scrutinized to determine whether they should be admitted at trial or not. Our law has therefore evolved both rules and rights to determine and govern the taking of statements from accused persons in custody. What are those rules and rights? We know from a growing body of academic literature, actual cases, and commissions of inquiry that false confessions cause wrongful convictions. The common law rule, excluding involuntary confessions, remains the best protection against coercive interrogations. There are also many rights under the Charter of Rights and Freedoms that apply when a person is in custody of the police. For instance, Section 10A of the Charter guarantees the right to be informed promptly of the reasons for the arrest or detention. And Section 10B of the Charter guarantees the right to counsel for persons who are detained. At the heart of these rights is the facilitation and protection of one of our most cherished and important rights, which is the right against self-incrimination. The reason these rights are afforded is because when a person is detained by state authorities, he or she is at a significant disadvantage. Their liberty has been taken from them and they are at risk of incriminating themselves. That's why a person who is detained is in immediate need of legal advice in order to protect his or her right against self-incrimination and also to assist that person in regaining his or her liberty. Until the police have discharged those duties, they must refrain from questioning or otherwise attempting to elicit information. The core principle and value underlying the right against self-incrimination is that when the state uses its power to prosecute a person for a criminal offense, that person should not be required to assist the state in the investigation or trial of the offense. When questioned by the police when in custody or detention, a person can assert their right to silence and say nothing. One can literally take a nap in the interrogation room, but what's most important is that asserting the right to silence cannot be used against that person. A judge or jury will never hear that a person refused to answer questions and exercise their right to silence. In the words of the majority of the Supreme Court of Canada, what the common law recognizes is the individual's right to remain silent. This does not mean, however, that a person has the right not to be spoken to by the state authorities. What that means is that the police can continue interrogating and try to obtain or elicit evidence despite a person asserting their right to silence. In that Supreme Court of Canada decision, the accused asserted his right to silence 18 times, but the court nevertheless upheld admissibility of the incriminating statements. During an interrogation, the police can lie about the evidence. They can claim they have witnesses. They can claim they have forensic evidence. They can interrogate for extended periods of time and can ignore requests to speak with counsel again. And even if the right to silence is asserted, they can try an undercover operation, planting someone in the accused cell who will try to elicit a statement. Many Canadians have grown up watching US television and are familiar with the scenes in which a suspect says they won't talk until their lawyer is present. In the US, they call these Miranda rights. Our law operates differently. Once the police have provided a means to access counsel, they can interrogate for many hours and there's no right to have counsel present. The right to silence involves the right to choose whether to speak with the police. The techniques the police use to overcome the right to silence arguably undermine a person's ability to choose, and it creates the potential for false confessions. One study, involving a method known as the Reid technique, described it as a confrontational, guilt-presumptive, psychologically manipulative process that can cause susceptible individuals, especially children and adolescents, to falsely confess. Many of those exonerated by organizations such as the Innocence Project made falsely incriminating statements or confessions. Marathon interrogations can, for instance, lead to a lack of sleep, which obviously has a disorienting effect on an individual. It can affect their memory and even cause them to make irrational choices. Interrogations can be endurance contests, ones that the police have been trained for, and in which they can sub in and sub out officers. After hours of intense questioning, some people have confessed as a short-term solution, believing that the other evidence will later prove them innocent, and many of those people have been wrongfully convicted. Because of all of these dangers, In recent years, several jurisdictions throughout Canada have made changes to how they interrogate suspects in an effort to come to terms with what we have learned about false confessions. One best practice has been the evolution of the requirement of video recording the entirety of the police interrogation. All of these rules are rooted in a concern for the integrity of the administration of justice and fundamental principles of fairness, in particular, the principle against self-incrimination.